Okay. As Colin said, good morning, good evening, depending on where you are. I'll be just giving a very quick run through of a quick reminder of what happened on that fateful morning. I'm sure everybody here over the years has seen it and read about it 100 times, so I won't dwell on it too much. Needless to say, it was on the 18th of May 2011, way back when the CMA CGM Libra departed Xiamen. She was on passage to Hong Kong. She had a pilot on board for departure, but the pilot disembarked, pilot away 0013. Her draft at the time was a little over 15 meters. The passage plan that came under so much scrutiny had been done by the second officer on board. I should point out that with it being 2011, this was actually paper charts, although there was an electronic chart on board. It was not an approved system, so she was navigating on paper charts at the time. On the screen there, you can see a plot of the AIS, which we've recently done to remind everybody. So, as I said, the pilot left midnight. And at 0221, on the way outbound, the vessel was passing where you see her now at buoy 15. As we progress to 0225, we'll see her alter course to 138. And then at 0228, a further alteration of course to 170. There was some effort to re-enter the channel, but we're not quite sure. It's still not 100% clear in all the investigations why the decision to exit the channel was made. She passed very close to buoy 14, approximately only 2 cables as she exited to the west of the channel. The vessel was confirmed as grounding at 0235 in, at that time, charted depths of between 27 and 30 meters of water. Interestingly, there was a notice to mariners, a T&P notice out at that time about the channel depths. So where the vessel grounded was actually previously, historically, a former mined area, and therefore hydrographic surveys had not been possible. So the preliminary notice, which for accuracy was NM 6276P10, actually stated that depths outside the channel were not as charted and were not accurate. And yet still the decision was made, as I said, not entirely clear. There was some things said by the master, but it wasn't entirely clear about why he left the channel. Also, as a matter of interest, there were no no-go zones on the chart or indicating what had been raised by the T&P notice. Not only is that good practice, it was actually a requirement under the vessel's SMS as well. So that was a quick reminder as to what actually happened that day. So if we move on to the next slide, please, Colin. Also, by way of a very quick reminder, the general standard and method of passage planning that should be applied by your crews out there. So it's a very 4-stage process: appraisal, planning, execution, and monitoring. This is something we've all heard a million times. It has been this way as long as I've been at sea, and the method has not changed through the years despite changes in technology. The reason it hasn't changed is because if it's done properly, it does work. So just as a reminder about appraisal, this is an information gathering stage where we gather everything together before we put pencil to chart or we put mouse on the ecdis. This is the area where we get things like notice to mariners, T's and P's, nav warning. We concern ourselves with chart accuracy, chart requirements, scales, any local requirements, weather, underkeel clearance, potential traffic in the area, any local requirements such as MARPOL, anchorages, where are all the anchorages in the area. And we gather this information from notice to mariners, sailing directions, list of radio signals, list of lights, the Admiralty digital catalogue. And we look at all these things and we gather it all together to what is pertinent for us on this passage. And then we move on to the planning phase. So the planning is where we take all the appraisal information and we apply it to forming the plan. We actually put pencil to paper or start putting lines on the ECDIS. And that doesn't mean just putting a course line down. We gather the information such as temporary and preliminary notices, and we put those down as well to warn the people and the people following the plan what is entailed. It's detailed plan, berth to berth, including navigational warnings, T's and P's from the appraisal stage. And it should also include a detailed narrative telling you all about each leg and what applies to it, where the information again from appraisal stage should come up. The final plan should be reviewed and checked by the master and approved by him or her and by the crew that are going to carry it out as well. And you should have a pre-planned meeting. Execution and monitoring is literally executing that plan, going along the intended course and monitoring your progress along that course as well for monitoring. I think as we listen to David and I hand over to him, we'll realise why I've laboured a little bit more on the appraisal and planning stages of this method. David, over to you.
Thank you, John. I'm going to take the story forwards now to what happened at trial. So John has described the circumstances of the grounding. After the grounding, owners incurred expenses, including salvage, which they put into general average. And cargo's proportion of that was some $13 million. Most of the cargo interests paid their share voluntarily, but a minority of interests refused to pay. According to the judgment, about 8% declined to pay, all represented by the same firm, and that was worth about $800,000 of uncollected GA. And in order to justify their decision not to pay voluntarily, those cargo interests argued actionable fault, that being a specific defence to the obligation to contribute in general average under Rule D of the York Antwerp rules. Now, various things can constitute actionable fault. In this case, the cargo interests pointed to unseaworthiness. Now, in order to succeed on that defence, cargo interests had to prove at least two things. First, that there was some reason why the vessel was unseaworthy at the commencement of the voyage, so before the master departed from the port, and also that that unseaworthiness was causative. In other words, if the vessel had been seaworthy, the grounding would have been avoided. Now, there are four things that the cargo interest pointed to claim that the vessel was unseaworthy at the commencement of the voyage. First, they said that the crew were incompetent. Now, it was necessary for them to say that the crew were not merely negligent during the voyage, because mere negligence during the voyage isn't sufficient to amount to unseaworthiness. You have to show that the crew were more than just negligent, that their actions resulted from incompetence. And that is usually proved by either showing that the crew were unable to do their job properly because of a lack of skills or training, or that if they were able to do the job, they were disinclined to do it properly. The second aspect that cargo interests focused on was inadequate bridge team management. They said that those on the bridge failed to communicate properly with each other. The third thing was fatigue. In particular, they said that the master's decision-making was affected by fatigue because he'd had insufficient rest hours. Now, all three of those issues were dismissed by the trial judge. It was the fourth aspect that the trial judge alighted on when he found that the vessel was unseaworthy, and that was, as John has described, the defects in the passage planning. In particular, the trial judge decided that prudent passage planning required the danger created by the presence of depths less than charted outside the buoyed fairway to be noted on the chart. And that failure to mark up the chart during the passage planning process rendered the vessel unseaworthy. Now, as I said earlier, that was only one of the things the cargo interest had to prove. They also had to show that the failure to produce a proper passage plan was causative of the grounding. And in this respect, it was important that the master's explanation for why he departed from the buoyed fairway was that he intended to do so. He didn't say that it was a mere accident, that he lost positional awareness or lost control of the navigation. He said, according to the judge in his judgment in his initial witness statement, that he was concerned about shallow water in the fairway and that he decided consciously to leave through the buoys because he thought that there was plenty of water outside the buoyed fairway. So he was relying on the charts. He was relying on the charts telling him that there was 30 meters of water outside the buoyed fairway. And so that enabled the judge, and if we could go to the next slide, please, to conclude that had there been a warning on the chart about charted depths being unreliable, the master would have been most unlikely, said the Admiralty judge, to have decided to navigate beyond the buoyed fairway. So that was the essential ingredient to find that that unseaworthiness was causative. And one can imagine a future case on almost identical facts, but where perhaps the master's negligence was just in accidentally leaving a buoyed fairway, where even with a defect in the passage plan, that wouldn't be causative, but it was in this case. Next slide, please. So the Admiralty judge concluded that the vessel was unseaworthy, that unseaworthiness was causative of the grounding, and therefore the owners failed to recover general average. They appealed to the Court of Appeal last year, and this year the case was taken to the Supreme Court. The Supreme Court, in short, upheld the judge's decision, and the essence of their decision is that negligent navigational decisions taken pre-voyage are capable of amounting to unseaworthiness. In relation to passage planning in particular, the Supreme Court decided that mistakes made during the appraisal and planning stages, as John has taken us through, are capable, where there are serious defects pre-voyage, of amounting to unseaworthiness. But because the unseaworthiness has to manifest pre-voyage, one is not concerned with mistakes in passage planning in terms of execution and monitoring stages. And for that reason, Lord Hamblin in the Supreme Court made the observation that you see in the quotes there on the right-hand side of the slide, that most negligent navigation will occur during the voyage rather than before it. And it is correct, said the judge, that the main burden of resulting cargo damage or general average claims is likely to fall on cargo owners and their insurers rather than ship owners and their P&I clubs. So there's a limited number of circumstances in which pre-voyage planning might be sufficiently serious to endanger ship and cargo, such as to render a vessel unseaworthy. However, the doctrine is likely to extend beyond passage planning and encompass any pre-voyage planning, provided the defects are sufficiently serious. Next slide, please. Now, I'm going to focus in the next few slides on a few important aspects that come out of the Supreme Court's decision in this case. And the first is a key question which the owners asked the Supreme Court to address. And that is whether, when one thinks about seaworthiness, are we only concerned with what has been called an attribute of the vessel? And that means that seaworthiness was previously thought to only relate to things which are maybe physical defects or systemic issues with the ship. And there's good reason to think that this is a requirement for finding that a vessel is unseaworthy, because in 1997, in a case called the Apostolis, the Court of Appeal had said, and you can see the quote in the red bubble, for a ship to be unseaworthy, there must be some attribute of the ship itself which threatens the safety of the cargo. And so the owners said that passage planning was not an aspect or attribute of the vessel, but it was instead a navigational decision. It was a navigational decision taken pre-voyage, and the passage plan was merely a record of those navigational decisions. By contrast, seaworthiness was about navigability of the vessel, not how it is in fact navigated. Now, that argument had been dismissed by the trial judge and the Court of Appeal, and it was also dismissed by the Supreme Court. The Supreme Court decided that there is no attribute threshold as a matter of law. So that means that it is not necessary for cargo claimants to prove in every case that the defect or state of affairs they rely upon as constituting unseaworthiness relates to an attribute of the vessel. However, the Supreme Court did not do away entirely with the concept, because there are cases, as we've seen, that talk about it. What Lord Hamblin said is that if there is an attribute threshold, then it must be widely and diversely drawn. In other words, there are many things, even if they are attributes of the ship, which can render a vessel unseaworthy, including things like passage planning. And he also said that attribute of the vessel may be an illustrative rather than a prescriptive requirement. In other words, one does not need to ask in every case, is the defect or state of affairs an attribute of the vessel? But asking that question may help illustrate whether the defect is sufficiently serious so as to endanger ship and cargo. Next slide, please. The other thing that the Supreme Court looked at, which is of importance to future claims, is the so-called prudent owner test. This is a way of assessing whether a defect or state of affairs is sufficiently serious so as to render the ship unseaworthy. And the test is to ask, would a prudent ship owner have required that the defect be made good before sending his ship to sea had he known about it? So pausing there, this test imagines a hypothetical owner made aware that something is wrong with his ship, and he's asked the question, well, now I've told you what the problem is, would you fix this problem, yes or no? The problem with this test is that it inevitably answers in the affirmative. It is very hard for an expert in a case to ever say, well, if I'd known about that defect, I would have ignored it. And there are many cases which have not applied that test. In the Aquacharm, for example, the master had overloaded the ship. And this meant that before it could pass through the Panama Canal, the ship had to be lightened. Now, had the hypothetical owner been asked before the vessel set sail, your ship is overloaded, do you want to fix that? The prudent owner almost certainly would have said, yes, of course I should. But the Court of Appeal in the Aquacharm said, no, the vessel is not unseaworthy. Even though she was overloaded, this didn't affect the safety of the ship or cargo. It was not enough to render the vessel unseaworthy. So what the Supreme Court said in the CMA CGM Libra is that the prudent owner test is a helpful test, but it's not a universal test. They thought it was well suited to dealing with evolving standards, and that is that the standards for ships change and generally improve over time. But they thought in many cases there is perhaps a more fundamental question to be asked, and that is whether the defect or state of affairs is sufficient to affect the fitness of the vessel to carry the cargo safely on the contractual voyage. And if the answer to that question is no, then the vessel would not be unseaworthy. Next slide, please. Now, before I conclude this section, I want to draw out 4 other points from the Supreme Court's decision, which again are perhaps of use to future claims. The first point is really not a very controversial one, but it's something the Supreme Court dealt with nonetheless. And that is that your Article 4 defences under the Hague and Hague-Visby rules do not apply where there is an actionable breach of the seaworthiness obligation. Now, your Article 4 defences are things like negligent navigation, fire, perils of the sea. They apply to a breach of the duty to care for cargo, but where there has been an actionable breach of the seaworthiness obligation, they simply don't apply. The second point that the Supreme Court emphasised is that the duty to provide a seaworthy vessel is not equivalent to a duty to provide a perfect ship. As we've already seen, the defect must be serious, and not all defects are capable of rendering a ship unseaworthy if they don't affect the fitness of the vessel to carry the contractual cargo. The third point is that a ship is not unseaworthy if an owner can reasonably expect the defect to be remedied before any danger to ship or cargo arises. Now, the classic example given in relation to this is a porthole left open as the vessel leaves port, but the owner can reasonably expect that the crew would shut that porthole before the vessel encountered severe weather. In those circumstances, the vessel would not be unseaworthy, even though one might say that a prudent owner would have liked the porthole to have been shut. The fourth point is that an owner is not responsible for negligence before the ship and cargo comes into its custody or control. Now, this is sometimes known as the carrier's orbit. So, for example, if there is some negligence in repairs to the vessel or maintenance before the owner acquires the ship, then that is not something for which they are responsible as a matter of seaworthiness. Equally, if there is something to do with the cargo, for example, if it is unusually dangerous or misdeclared, and that happens before the cargo comes into the custody and control of the carrier, and that again is not something for which they are responsible. That is, unless either of those things is reasonably discoverable after the ship or cargo comes into the custody or control of the owner. So having dealt with those 4 points, I'll move on to the next slide.
Hello again, it's back to me. Just a very quick reminder, thank you, David. Just a very quick reminder of some of the reference material out there. As we can see, the appraisal and planning phases were the ones under spotlight here in the case of the CMA, CGM and Libra. That's not to say the other two aren't important, but in this case, they were the two under the spotlight. And there's some excellent reference material out there. The ICS Bridge Procedures Guide gives a very detailed breakdown of the appraisal and planning phases. This is right up to date now as well, to include information to do with ECDIS on that as well. And I think it's an excellent read for seafarers, that particular document. It's very clear, it's concise, it's checklist in its nature, as opposed to being long paragraphs about the information and the details. It's a good document for you to read to base your SMS procedures on as well. The IMO resolution has been around for a long time now. It's a heavier read for seafarers, but something you should definitely be referencing when it comes to your procedures and going through. MGN 166 by the Maritime Coast Guard Agency is a clearer, clearly references the IMO procedure, slightly clearer fashion. Again, these M notices are brought out for seafarers to read to make them a little bit more palatable. And all of these things should be referenced, and you should have a clear and concise procedure for this in your SMS. Remember who the procedure is written for. It is written for the crews that will be carrying out the passage planning. So it needs to be clear, it needs to be simply worded. It is for them to understand and easily find and easily follow as well. So just a little reference there to some good material for you to go and have a look at if you want to make sure that your procedures are in line with the latest reference material and guidance that is out there. Thank you.
Thanks, John. Thanks, David. I think that was clear. Apologies that our little animation at the start didn't run, which I think threw John a bit, but nothing's ever smooth with technology, even when you test it in advance. We've got a couple of questions in. I think the first one probably for you, John. What is the definition of a voyage, so that we can understand the pre-voyage stage?
It's an interesting question. I think from a technical point of view, as we discussed, when you're doing the plan, you've finished your appraisal, and you're doing the plan, it absolutely must run berth to berth. So it's not from open sea or anything like that. From a passage planning technical point of view, it's from pilot on board, letting go the lines at one berth to all fast finished with passengers at the other berth. And your appraisal must absolutely cover those areas as well, the berth to pilot, pilot to berth area. So the pre-voyage section of it, if you like, is something that's relatively last minute, because if you want to include tides and currents, you're going to need to know your ETD or your ETA at that berth to see how it's going to affect you, and that should be included in your plan as well. So I would suggest that it's always berth to berth prior to letting go and when all fast at the next port.
Thanks, John. I think the next question gets to the heart of this case, really, in terms of how owners should react. What kind of due diligence are owners expected to take in the light of this decision? Probably one for David on the legal side and one for John on the practical side.
Thanks, Colin. I'll go first, perhaps, in terms of the legal aspects. If we're thinking about what sort of things an owner can do to try to ensure the vessel is seaworthy, so that the key of this case is that pre-voyage negligence by those on board can render a vessel unseaworthy. From the owner's point of view, they need to ensure that their crew have all the training and tools needed to properly passage plan. But this case doesn't represent any increase in the standards required. Had the passage plan in this case been done in accordance with good practices, had the warning to mariners been noted in any way on the chart, then this vessel would not have been found to be unseaworthy. The other aspect of due diligence, I suppose, is the normal defence where the ship is found to be unseaworthy, which is that a carrier can say, even though the ship was unseaworthy, I nonetheless exercised due diligence to ensure that it would be. The problem with this sort of case is that that defence is really not available where negligence itself has rendered the vessel unseaworthy. So it's no good for the carrier to say, as they tried to in this case, even though the vessel was unseaworthy because the crew negligently prepared for the passage, I, the carrier, nonetheless exercised due diligence to make the ship seaworthy because the negligent failures of the crew were attributable to the carrier. So it followed in this sort of case that was no defence to the claim or to the GA defence. As to the second question, from a legal point of view, would non-negligent errors in passage plan render a vessel unseaworthy? Well, no. We are looking at negligence here, a negligent failure to prepare a proper passage plan. If a passage plan is prepared non-negligently, then it won't be defective and it can't render the vessel unseaworthy.
Okay, thanks, David. So from a practical aspect, John, does that mean owners have to do anything different?
As David said, and I entirely agree, this isn't a shout for a new standard. As I said on one of the very early slides when we were discussing the method, appraisal planning, execution and monitoring is as old as time. And the reason that it hasn't changed is because if it is done properly, it works. It is a system that works. It doesn't need changing. So the key really is, for me, about ensuring that it is being done properly. and by the crews, in my opinion. And I don't think there's anything that's required that good owners aren't already doing. Auditing their bridge teams is already getting done by most operators. Now that can be done remotely as well as in person. I understand that is in-person auditing is difficult, particularly at the moment. People are on bridge resource management courses. Of course they have to be, but it's just about making sure that the contents of that course is covering things properly, and making sure that they're going on the course, and the colleges or whoever you're putting these on, if it's internal, and making sure that enough highlight is put on the existing standard of passage planning. So I don't think there's any need to really push the boat out with new things. It isn't a new standard. It's just about ensuring that your crews understand the importance of it, and that they are conducting the existing standard to the correct level. Be that auditing, as I say, is quite an important phase in that, in my personal opinion, and making sure that new things that come in are properly communicated to the crews, such as where to get your T&P notices and things like that. Make sure that the understanding and the foundations and the knowledge is correct, and that they're meeting the existing standard.
Okay, thanks, John. David, back to you. So, from my perspective, it seems to be fair to say that some of the wilder commentary around CMA CGM Libra is probably not justified, and it's not as highly significant as some of that commentary would suggest. Is that right?
I'd agree with that. Certainly, that there has been some wild comments about the significance of this judgment. It certainly expands on what we think of as constituting unseaworthiness. So, as I said earlier, previously people did think that seaworthiness was really about physical defects, systemic problems, and that issues of navigation fell outside. And we now know that's not the case. But there were plenty of judgments where things other than physical defects have been found to render vessels unseaworthy. I think in terms of future impact, this decision first came out from the Admiralty judge in 2019. We do see more claims where it is alleged that passage planning was defective. Quite often, there's either no problem, or at least no serious defects with the passage planning, or whatever problems there are not causative, either because they didn't lead the master or other officers to make the navigational mistake they did. Remembering in this case, this was an intentional decision of the master to leave the fairway, or because the problem with the passage plan is in how it was updated or corrected during the voyage. And whilst that's not ideal, that's not legally enough to render a vessel unseaworthy. So we probably see about 5 claims a year which involve this sort of allegation, and not many of them really cause very much concern.
So it's a bit of extra grit in the mill, but it's not a complete disaster for us.
So, certainly not, and easily dealt with through, as John has said, to just reinforcing good standards in terms of passage planning.
Just another point on cover, David, to clear that up. If there is a finding of unseaworthiness in the passage plan, can you explain to our members how that works, please?
So cargo claims or unrecoverable GA which results from a finding of unseaworthiness is an essential component of club cover. So your cover will respond in those situations. It's only in the exceptionally rare case of a vessel being put to sea where the owners or the managers have privity of the unseaworthiness, the cover might be prejudiced. But on the facts of this sort of case, that wouldn't arise.
Okay, thanks, David. John, I've got a question that relates to technology, funnily enough. With the move to electronic navigational charts and T's and P's being updated automatically to those, do you think a similar situation could arise today?
Yeah, thanks. I think that's a really good question, actually, and it's It's one of the things I mentioned before in one of the questions where I said making sure that crew understand and that the latest problems are communicated well with them. And excuse me, transition T&Ps are one of those things that is a little bit of an issue with the use of ECDIS. That is because it depends on which hydrographic office you are looking at the chart for as to how they communicate those T's and P's. It has been raised by a member of ours, quite rightly so, and we have discussed it with the UKHO as well, who is well aware and are discussing it with the IHO. The problem is that some communicate by updating the E&C. So you'll get an actual mark on the E&C as a temporary or preliminary notice. Some will put a caution mark on the E&C. Some will appear on the Admiralty information overlay. Some will not appear at all and will have to revert back to checking the T&P list, depending on the hydrographic office that you're looking or that you're dealing with at that time. And therefore, that's something that should clearly be communicated to crews, as I said before, is that really you can't just rely on one source of information for your T&Ps when it comes to ECDIS. You have to check them all. And really, at the moment, the best way of doing that would be to check the list to make sure, to see what is pertinent to the area that you're navigating in. Everybody knows they're still ironing out creases in the use of ECDIS. The benefits of it most certainly, in my opinion, outweigh the negatives, but this is one of the things that is still being currently ironed out. And as I said, the UKHO, who we speak with a lot, are definitely well aware of this problem, are one of the prime movers in trying to resolve it. But it's a really good question when it comes to T's and P's. Definitely need to check more than one source of information, and probably, regardless of all the technology in the world, the best source of information for that is just the normal T&P list. Just to double, triple check that you have everything that is pertinent to that passage. I mean, that also reverts back a little bit to the bridge resource management training that I mentioned earlier. There is a school of thought, which I personally agree with, that maybe ECDIS use and passage planning on ECDIS and T's and P's and all those things that go into ECDIS use isn't yet taught enough. It's still teaching in colleges and cadets and things too much on the paper charts and where to get those things, and not quite enough on the reality of the coalface, which is that everybody's using ECDIS at the moment. And maybe it's down to the ship operators to start pushing that a little bit where possible, to up the standard in the understanding of technology rather than the things that are as old as time, such as appraisal, planning, execution and monitoring.
Okay, thanks, John. David, final question from me, and I welcome questions from the audience in the chat function, please. You mentioned the attributes of a vessel. So is there potential for owners to be open to allegations of unseaworthiness for other attributes that perhaps they probably wouldn't have been before this judgment?
I think what the Supreme Court was really saying in its judgment is that this has long been the case, that that things which happen pre-voyage, which don't necessarily relate to the physical state of the ship or the ship's systems, like its SMS. There have been plenty of decisions in the past which have looked at things like failure to take on sufficient fuel, failure to putting on bad bunkers. These sorts of things have in the past been determined to render vessels unseaworthy. So what the Supreme Court is really doing is making it clear that that is the rule, that if you have something which exists pre-voyage, which is sufficiently serious to pose a danger to ship or cargo, and a prudent owner would put that right before departing on the voyage if they'd known about it, then that is capable of rendering the vessel unseaworthy, and will be actionable if it's causative. But also, if you're looking at pre-voyage negligence, so things like stability planning, then you're not going to be able to rely on a due diligence defence, because it's axiomatic that if negligence renders you on vessel unseaworthy, then you're not going to be able to say, but I wasn't negligent, I exercised due diligence.
Okay, thanks, Dave. That's clear. Another couple of questions in. John, if on a short sea route and a very fast turnaround in port, there's changing T's and P's just prior to sailing, do you have to act on that?
Personally, yeah, I think you would have to. I mean, it's part of the appraisal stage, and appraisal, as we discussed earlier, should be berth to berth, from letting go to finish with engines all tied up at the next berth. So, yeah, I mean, given the impact of some of the T's and P's that you see, yeah, I think really we should be checking. They're as good as a nav warning, aren't they? So we should definitely be checking on those T's and P's. In my opinion, as I discussed with you, Colin, the other day, are one of the things that, okay, it's been thrown into light here, but they were weekly dealt with, even when we had paper charts. And I think that this is one of the things, when somebody asked earlier, what should we be doing? It's enforcing a good standard. This has always been a standard, that you check the T's and P's, you mark them on the chart, and or check they're on the ECTIS. So yeah, I do think that we should be checking prior to sailing. That's part of the appraisal for that passage.
Okay, thanks, John. And David, what are the other tests other than the prudent owner test? What else does the code take into consideration?
Well, so just to be clear, what the Supreme Court said is that they thought the prudent owner test was a helpful test and applies in most situations, but that they thought that there would be cases on the borders where there might be a more fundamental prior question to ask, and that is whether the defect in the ship or the state of affairs, which cargo interests are pointing to, are sufficiently serious so as to endanger the ship and cargo. And that's to explain cases like the Aqua Charm, where the vessel is overloaded, but it's not posing any danger to the ship or the cargo. As one judge in a different case described it, they called it a mere hindrance, an inconvenience that the ship had to lighter. There was no danger there. So it's that more fundamental question. In a lot of this is probably going to turn on more cargo worthiness and cases of bad stowage, for example. So in a case called the Thorsa, Gorgonzola cheese had been put next to quite expensive chocolates, and the cheese contaminated and spoiled the chocolates. But again, no danger to the majority of cargo, no danger to the ship. A prudent owner, if they'd known that the chocolates and the cheese were put together, would have required them to be moved. But that's not sufficiently serious to render a vessel unseaworthy. But those cases are probably at the border.
Okay, thanks, David. I don't think we've got any more questions, so I think we'll bring proceedings to a close. There has been a recording, and we'll make it available to everybody who registered. If you do want to talk to somebody at North in more detail, just get in contact with John or David or your usual contact at North, and we'd be happy to talk things through you in more detail. Thanks very much for attending, and thanks very much to both David and John for a good presentation, and we hope that things are a bit clearer in terms of the judgment and the potential actions for you as owners.